The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
Good morning to everyone. The first case is Gay versus Saber Healthcare Group, L.L.C. et al., and we'll hear from the appellant.
May it please the court, Chief Justice, Associate Justices, my name is Brad Overcash, and I, along with my law partner Daniel Peterson, represent the appellants in this case, Saber Healthcare Group, LLC, and Autumn Care of Rayford. This is a case about the enforceability of an arbitration agreement between a nursing home resident and the facility, and we would reserve 10 minutes for rebuttal, please. Autumn Care of Rayford is a skilled nursing facility located in Hope County, North Carolina. And Ms. Franklin was at the time an 84-year-old lady who suffered from dementia, suffered from Parkinson's disease and other health conditions. Her responsible party and daughter, as well as appellee, well, not appellee, but her responsible party and daughter was Ms. Leitner. And prior to coming to Autumn Care, Ms. Franklin was a resident of a facility known as Carolina Inn, and it was determined that she needed skilled nursing care. And so Ms. Leitner, on her mother's behalf, took a tour of Haymont Rehab and Nursing Center. And then subsequently on April the 10th, 2017, Ms. Leitner visited Autumn Care of Rayford, spoke with staff, and took a tour of the facility. 8 days later, on April 18th, 2017, she returned with her mother, so Ms. Franklin and Ms. Leitner, to Autumn Care of Rayford, in which they took another tour and had a meeting with two facility representatives when they decided that they wanted Ms. Franklin to be a resident, admitted as a resident to that facility. During the meeting with Ms. Leitner, Ms. Franklin, and the two Autumn Care representatives, they were presented with, by the facility, an admissions agreement and a separate arbitration agreement for their consideration. Ms. Leitner described that meeting in the record, and this is record page 47, as very relaxed and social. During that meeting, the final page of the arbitration agreement and the final page of the admissions agreement were signed by both Ms. Keys on behalf of the facility and Ms. Leitner as the personal representative for Ms. Franklin. Both of those documents were signed, and those are at record pages 49 and 50. And Ms. Franklin, as a result of signing that admissions agreement and then voluntarily also entering into the arbitration agreement, or rather Ms. Leitner signing it on Ms. Franklin's behalf, then Ms. Franklin became a resident of Autumn Care of Rayford on April the 18th, 2017.
Let me ask you this, Mr. Overcash. It seems that a lot of facilities, medical care groups are moving more and more to just giving individuals a sign pad, let them sign. While that may be an efficient way to do things, is there any type of, or is there a need for the individual to have the full copy of a document to appreciate what they're signing in general? That's the first part. But then specifically with regard to the waiver of the right to a jury trial.
Chief Justice Newby, we do not believe that it has to be presented in physical form, and the record in this case indicates that these two agreements were presented both on an iPad in electronic form, and also some physical papers were presented. I don't know that there's any legal difference as long as the party to be bound, in this case, the appellees, as long as Ms. Leitner had the opportunity to appreciate and understand what she was signing. And so I don't believe that there's any type of requirement that it's printed in physical form. And as far as signing a pad, there's I don't believe there's even an allegation that some sort of specific signing pad like you would do at a retail outlet, signing over a credit card. At a minimum, the final pages of both of these agreements, and importantly, the final page of the 3-page arbitration agreement, were all. I'm getting some feedback here. I hope y'all can hear me. The final page of the arbitration agreement, which is found on record page 50, while it's only the third of 3 pages of that agreement, that's the page that's signed. It's signed by both Ms. Keys for the facility and Ms. Leitner, and it contains a great deal of information that shows exactly what Ms. Leitner was signing. So at a minimum, the acknowledged page of the agreement.
Mr. Overcash, if I understood what the Chief Justice was asking about, it had to do with the availability of documents to the signatories. The record, at least as I understand it, reflects that sometime substantially later, there was a hard copy presented to Ms. Leitner, but at the time that the documents were signed, was any offer made? I mean, was any offer made to provide an electronic copy to the signatories? Anything of that nature?
No, Justice Urban. Neither a full electronic copy, nor a printed copy was provided on the date that these 2 agreements were signed. Neither was presented to Ms. Leitner.
So basically, as you understand the record, what happened is that an iPad was provided that contained at least the signature pages. There was a mechanism on the iPad that permitted a signature. And so what happened was a series of signatures on the signature pages.
Well, Justice Urban, at a minimum, and I want to be clear about the signature pages, so let me take a look at that if we can. Yes, at a minimum in the record, even in Ms. Leitner's affidavit, there's no dispute that she signed on the signature page for the admissions agreement, which is record 49, and the arbitration agreement on record 50. But I hope the court will understand they're more than mere signature pages. So on those pages contain a great deal of information. And for example, on the admissions agreement, I'm sorry, on the admissions agreement, the provision that's in question here that the trial court deemed incompatible with the arbitration agreement is contained on that signature page. So the admissions.
So just to make sure I'm following you, when you're talking about text that could be seen, you're talking about the text that appears on the page upon which the signature was later affixed.
Yes, Your Honor.
Okay, yes. Thank you.
That we know was, or at least this court can recognize was or should have been reviewed by Ms. Leitner at a minimum, each of those pages, because Ms. Leitner's signature appears on that page.
Mr. May I follow up on this topic just to ask you about the status of the trial court's findings of fact? Because aren't we bound by, as long as there's competent evidence in the record to support it, bound by the trial court's finding of fact number 5? This is on page 98 of the record. The trial court's order found as a fact that only the signature paragraph was presented to Ms. Leitner for electronic signature in very small print on an iPad, and pages 1 and 2 of the purported 3-page document were never available, shown, or explained to Ms. Leitner prior to her electronic signature. Are we bound by that as a fact in this case?
Yes, this court is bound by the actual findings of fact of the trial court, as long as those findings of fact, as the court, even the Court of Appeals pointed out, don't move over into conclusions of law. And what you read, Justice Earle, I agree, is a finding of fact. But as I read that finding of fact, and as I believe any reasonable person would read and understand that finding of fact, I would direct your attention to the actual pages that are given. So you mentioned the 3 pages of the arbitration agreement. The 3rd page of the arbitration agreement, found on record page 49, has 5 different paragraphs on it with this dense, with very important information that Ms. Leitner would have had the opportunity to review, should have reviewed, and then did sign off on. And so even if we take the trial court's finding of fact and grant it as true for purposes of this hearing or these oral arguments today, we would still have the information contained on record 49 for as far as the admissions agreement. And if I can, just to draw the court's attention to some of the language that was contained in that agreement, and thank you for that, Justice Earls. But
let me ask a follow-up real quick. There's also a finding in the trial court's order, paragraph number 4, that within that dense language on page 49 of the record, that the terms jury trial and bench trial within the same sentence would not give a reasonable person notice of arbitration and would not be understood by someone who does not have training in interpretation of legal documents. And then the affidavit goes on to say that Ms. Leitner at least never heard anybody talk about or explain arbitration. Aren't we bound by that finding of the trial court as well?
No, Justice Hudson, because even though there's a title of findings of fact, all of these paragraphs are titled findings of fact in the trial court order. But the second provision of paragraph 4 is clearly a conclusion of law. And so if you look at paragraph 4, breaking that down a bit, appellants concede that it is a finding of fact of the trial court to say that defendant's admission agreement, specifically within the terms of the admissions agreement signature page, states, and then they have the quote from that. But then the next sentence is, the court finds that defendant's use of the terms jury trial and bench trial within the same sentence would not give a reasonable person notice of arbitration and be understood by someone who does not have training. That we would submit to the court is a conclusion of law.
Well, isn't reasonableness typically a finding of fact, and a jury trial would be for the jury, or here for the finder of fact?
Your Honor, when we're looking at questions about, let me look at that, Justice Hudson. That is I would not agree with that. It is a conclusion of the court that it was that reasonableness wasn't given there, and not something that would go to some determination of, it would go to a determination of ambiguity that would cause that to be reviewed. So no, I do not believe that is a finding of fact. It's not something that the trial court just determined did or did not happen. Rather, it's a legal conclusion as to whether or not those terms and these two different provisions in two different agreements, whether or not those are compatible or not, is a question of law for this court to determine. And this court has wrestled with different provisions in arbitration agreements and tried to decide whether it created some ambiguity such that the arbitration agreement would or would not be given. So that second part, it's our position, is merely a conclusion of law, and no, it is not a finding of fact that this court would be bound by.
If my memory serves me correctly, the arbitration agreement was not presented at the hearing, was it?
At the hearing, thank you, Justice Morgan. At the hearing, the arbitration agreement and or at least the final signed page, which you find on record 50, was attached to the plaintiff's brief in opposition to, the now appellee's brief in opposition, and was submitted to the trial court. And so it was submitted. It wasn't submitted by by the now appellants by counsel at that time. It was not submitted to the court, but I don't see any difference or distinction when it was presented by as an exhibit to the brief filed by and submitted by the appellee.
It was not presented as substantive evidence, though, by the defense in order to explain, even with an affidavit, as to how those provisions would be reconciled.
No, Your Honor, it was not. There was not an affidavit presented by the defense, and the arbitration agreement was not presented by the defense, but it was in the record. It was before the trial court, at least in the form of what you find on record page 50, and the admissions agreement. Similarly, the final paragraphs and signature page of the admissions agreement were attached as an exhibit by the now appellees at record page 49. So I agree, Justice Morgan. It was not presented by the appellants at that time, but it was before the trial court for consideration.
And as to, therefore, the findings of fact and the conclusions of law that were ultimately determined by the trial court based upon what was presented at the time, and the Court of Appeals having reviewed it as well, aren't we, as the matter comes through the court system in the appellate process, bound to the extent that those are pretty much taken as true and therefore valid?
No, Justice Morgan, the review, especially as to conclusions of law and the ultimate opinion in this case, the Supreme Court reviews that de novo. It is true, findings of fact, breaking down the question, findings of fact, as I've already stated, by the trial court and then carried up by the Court of Appeals, as long as they have competent evidence supporting it, according to the Slaughter case, are to be taken as true. But conclusions of law and the ultimate determination falls to this court on a de novo review. The presentation, without a doubt, regardless of which side presented it at the trial court level, which side did not present it at the trial court level, there's no doubt that what's contained on record page 49, the signed portion and the substantive portion of the admissions agreement, was signed by Ms. Leitner, signed by the facility. And the operative language is in the admissions agreement is quote, "The resident/representative and the facility hereby mutually agree to irrevocably waive any and all rights to trial by jury." And then parenthetically, while expressly preserving any and all rights to a bench trial, and that's from record 49. That's contained in the signed page of the initial admissions agreement. Now, that admissions agreement is required for any resident to become a resident of Alden Care of Rayford. That's a mandatory document. If someone doesn't sign that, or their representative doesn't sign that admissions agreement, they don't become a resident of Alden Care. Then
Did that create a fiduciary duty?
It did not, Justice Morgan. And my colleague, Mr. Peterson, is going to address that in greater detail, but we believe that the King case cited by the Court of Appeals is clearly distinguishable on the facts, and that a fiduciary duty was not created at that time. And if it's okay, I'll leave the additional details to my colleague on fiduciary duty, unless you want me to go ahead with it right now, Justice Morgan.
I'm fine with how you want to treat it.
Mr. Overcash, let's go back to something you said in the answer that you just gave to Justice Morgan. You referred to various language as mandatory, I think. When you use that term, were you talking about mandatory in the sense that some law requires it, or are you talking about mandatory in the sense that your client insisted upon it as a condition of admission?
Okay. Thank you for that, Justice Irvin. The admissions agreement, so not the arbitration agreement.
Right.
The admissions agreement is required by the facility
But that is the terms that are, quote, mandatory, are terms that are made mandatory because the facility, in its discretion in operating its business, chooses to make it so, not that there's some outside force like a regulatory agency that requires it. Is that right?
That's right, Your Honor. It's the facility's choice. It's not I don't mean mandatory in a legal sense. I mean that the facility requires all of its residents, and this is typical across this industry, requires all of its residents to enter into an admissions agreement where it's setting forth the terms of which the care is going to be provided to that resident. And a part of that is the provision where the parties agreed to waive their rights to a jury trial and then parenthetically reserve their rights to a bench trial. But I do want to make a clear distinction, and that's an excellent point, Justice Ervin. Unlike that admissions agreement, where the facility says we have to come to these terms before care can be provided at this facility. Unlike that, the separate and distinct arbitration agreement and the signature page and operative paragraphs found again signed by both parties on record 50. That agreement is a voluntary agreement. It is not required expressly by its terms. The facility does not require any resident as a condition of admission to enter into the arbitration agreement. And the key terms of that arbitration agreement, it states right at the top, and again, I'm from record 50, in bold, in all caps, resident and not bold, I meant all caps, resident and facility arbitration agreement, not a condition of admission, read carefully. And it goes on in paragraph 2, I won't read the whole thing, but in paragraph 2, some of the important parts, signing this agreement, and again, this is the arbitration agreement, not the admission agreement. Signing this agreement is not a condition of admission, and care and treatment will be provided to the resident, whether or not he or she signs the agreement. Paragraph 3 of that, the decision whether to sign this agreement is voluntary, solely a matter for the resident's determination without any influences. Going down to 6, the resident has had an opportunity to ask questions about this agreement. Number 7, the resident's had an opportunity to read the agreement and propose edits or revise terms or alter the agreement. And then going down to 8, just 2 more, please. The resident has had the right to seek legal counsel regarding this agreement and has been advised to retain legal counsel before signing the agreement. And paragraph number 9, this is in all caps and it's in italics in the document itself. On the
Mr.
page signed
Overcash?
by Ms. Leitner. Yes.
I'm sorry to interrupt you, but the
Yes,
time is a ticking. And I just want to go back to the trial court's order for a minute. In the order, it's just kind of a follow-up to my earlier question. There are 6 numbered findings of fact, and you indicated that you thought part of number 4 was not a finding. Would you agree that the rest of the numbered paragraphs are actually findings of fact? We reviewed to see if they're supported by the evidence?
No, Justice Hudson, I believe we would have to take that sentence by sentence. And particularly, I'm even thinking about, if you look at paragraph, just as an example, if you look at paragraph 3, the admission agreement, and this is of the first page of the trial court's order, the admission agreement, page 8, paragraph J of plaintiff's exhibit D, incorporated into the admission agreement by reference all documents, and then it has that, and then it states a conclusion, and this is next, that's a finding of fact. The next sentence is clearly a conclusion of law that the trial court's making. When the trial court says the document signed specifically, the agreement and signature page of the resident are internally in conflict with one another. One purporting to expressly reserve the right to a bench trial, one purporting to agree. And I would even turn to the majority's opinion.
Well, couldn't that just be a finding about what the language says? That it says one thing in one place and another thing in another?
I don't believe so, Justice Hudson. It's a determination by the court as to what's in conflict and what's not. Simply knowing what the words are to something doesn't allow the court to determine they're in conflict. For example, if we go to the Rouse case, and we've cited that in our brief, and I can find the I can find the citation of that.
So is it your position that whether the words are saying different things internally is a conclusion of law and not a finding of fact?
I believe the conclusion it would be whether or not those particular words are in conflict with one another. That's what I would submit as a conclusion of law. And even the majority opinion in the Court of Appeals makes this distinction. In the Court of Appeals majority opinion, they discuss what are listed as findings of fact and even state that, I'm getting there, I'm sorry, let me get there, Justice Hudson.
Mr. Overcash, I'll point out that you're well within your rebuttal time. Of course, you can manage your time as you desire.
Thank you, Chief Justice Newby. I will certainly make sure I answer this question for you, Justice Hudson. If you look at the trial court on page 8, paragraph A, they're talking about findings of fact even in the majority's Court of Appeals opinion. And then they move further to conclusions of law in B. And at one point, that a finding with more, I need to find the language, more appropriately, I may have to do this on rebuttal. The Court of Appeals noted that one of the purported findings of fact, because there were no conclusions of law set out separately by the trial court, did in fact serve as a conclusion of law. And so I'll say this and then reserve the rest of the time, the rest of our time for rebuttal. Well, actually, other than to say we do not believe that a fiduciary duty, a de facto fiduciary duty existed, and that was breached. We believe the King case on its facts is distinguishable because Ms. For a number of reasons, and we can address this more in our rebuttal time, but for a number of reasons. One being that Ms. Leitner visited and toured the facility 8 days prior to coming back to the facility with her and her mother and making this determination, versus the King case where there was a discrete medical issue where an existing fiduciary, the physician in the King case, sent a patient to a specialist for a discrete health issue. And with that, Justices, we will reserve the remainder of our time for rebuttal, please.
Thank you, counsel. We'll hear from the appellee.
Thank you, Your Honor. Chief Justice Newby and Associate Justices, I think the main issue before us today is, will the Supreme Court sanction a new contract policy of sign here electronically, and one side will fill in the details later? This idea directly impacts a parties to accurately evaluate a contract against others in the marketplace at an induced detrimental reliance. And that's exactly what we see here. To go back and answer Justice Newby's question earlier, even if it was signed electronically, were they required to provide a full copy of the contract before signing? And the answer is yes. To find a contract, whether it's an arbitration contract or any other contract, there must be a meeting of the minds. And in this case, the parties to arbitration, if that is what they want to do, must specify clearly the scope and terms of their agreement. And that's from the Burgess case, Burgess versus Jim Walter Holmes, 161 North Carolina Court of Appeals at page 491. What we have here, looking directly at the trial court's findings of fact, and specifically in paragraph 5 of the findings of fact, is that the court found that the purported, and you'll see the use of the word purported twice in paragraph 5 of the trial court findings of fact, pages 1 and 2 of the purported 3-page document were never available, shown, or explained to Ms. Leitner. That is a finding of fact. So if those were not shown, explained, or available to her, she did not see these. What we do know is that the trial court finding of fact that only the signature paragraph on Plaintiff's Exhibit C was presented to Ms. Leitner for electronic signature. And I'm going to go over this with the court, so bear with me for a minute, please, while I share my screen. Okay, I hope your honors can see this. So you will see on the screen, and please let me know if you cannot, you will see that this is page C. And I have it on the screen at 74% so you can see the entire document. When I move it to 100%, this is what you see. For ease of convenience,
Ms. First, I hate to interrupt you, but I've
Yes.
found over the years, if I don't do it when I'm thinking about it, I lose my train of thought, at least if nobody else's. Do we have any, is there any information record as to what degree of magnification this document was shown to the client? Or
what we do have are the findings that this was showed to her in an iPad in footnote-sized font that she was unable to expand. So looking at the document now, you can see I've made it 100% on the screen. I highlighted where Ms. Leitner has signed it. The only thing we know from the trial court finding of fact is that the signature paragraph was shown to her. And you will see where she signed in relation to the information at the top. And as you can see, it takes quite a while before a party can actually read this document. So what we know, according to the trial court findings of fact, is that she was shown the signature paragraph. We do not know that she was shown this at the top.
Let me ask you just kind of a broader question, which is, I know the tendency or the trend with medical records as well as other types of business transactions today is to use electronic versions and to reduce paperwork. And yet our case law seems to say that when a party is presented with a contract, they're presumed to know all the terms of the contract. It seems to me that the argument that you're making is not that one could never do an electronic signature contract, but in doing so, you can't just give the last page, but you have to give the full document in readable form and thus allow the party appropriate time to read and then to sign if you're going to do it electronically as opposed to with regard to a paper writing. So can you just help me in general as we think about kind of the 21st century and modern world, the desire to go paperless and at the same time to hold parties to their contractual obligations? Help me as I'm trying to sort through this.
Yes, Your Honor. So I do believe that a party, whether they're given a contract electronically or in paper, must be given all of the purported contract. And as we see from the purported arbitration contract here, it's not paginated pages 1, 2, and 3. The only page numbers that appear on these documents are those from the official Court of Appeals record. So a party would not even know that this page with the signature is a page 3 of a purported 3-page document if they are not shown this. As in a basic matter, if a party wants to have another party sign a contract electronically, they are required to show the party all of the terms of the contract, be it electronically or on paper. That must be done, and that must be affirmatively shown when someone challenges the fact, and that's what we have here.
Again, when you say that all of the pages or all of the content must be shown even in an electronic document, for purposes of those of us who are still stuck in the paper world, what does that mean?
That means that all of the terms of the contract. So to have a meeting of the minds of the terms, each party, each side must see all of the terms of the contract.
Okay.
So in this case,
in practically speaking, how would you suggest that one go about doing that?
practically speaking, it would mean that either all of the pages are given in paper form or electronically to be made visible. What we know in this situation is that they were not available. They were not shown to the person signing them. They were not explained to her. And when she asked for a paper copy, she was told they could not provide it. So this situation, there was no way for her to have obtained additional facts to know that there were more pages in a purported document because it doesn't even say it's a page 3. There is no evidence from which she could have even guessed. And that's what this is. They're asking her to guess or speculate. And requiring a party to guess or speculate that there are more terms to a contract other than what is put in front of you, it upends the duty here. It's the marketplace duty and even a fiduciary relation, which I would say is absolutely in existence at the time of the signing of this contract.
Can I ask you the next, or to follow up on that with the, to explain then, given the findings of fact that we have in this case, what is do we conclude then legally there was no contract, or that the contract only consisted of the pages that were on the iPad? What's the conclusion here, given the findings of fact?
The findings of fact are very specific to say that the purported pages 1 and 2 were never shown to the woman who signed them. They were never shown to the plaintiff. So those could not possibly be part of a contract because there's no meeting of the minds. We only know from paragraph 5 of the trial court's order that the signature paragraph was shown. The signature section simply has her signature. So there are no terms to a binding arbitration agreement, in large part because the admissions documents themselves say that the headings are for reference purposes only and shall not affect in any way the meaning or interpretation of the agreement. The word arbitration only appears in the headings. Since it only appears in the heading on that signature page, when you take that out, the word arbitration is not included at all on the signature page. So this is essentially a document that omits material terms, and the nursing home defendants are asking the Supreme Court to supply not only the terms, but their meanings, which is well beyond what the court should be able to do. And the trial court found that there was no arbitration agreement. It simply was not in existence. Moreover,
I mean, where does that, I mean, I realize that's not what this case is about, but I can't help asking. Where does that leave the agreement to present all controversies arising out of the agreement, I don't remember the exact language, in a bench trial context?
So, Your Honor, I think we have an interesting dynamic, and it was pointed out by the dissent on page 10. He noted that the contract that was apparently purportedly signed on that day either says you signed the admissions agreement and you waive the right to punitive damages, or you signed the arbitration agreement. So we have these terms that are conflict and that very much impact the client's civil rights. And what we also clearly know is that, according to the trial court's order, paragraph 5, no one explained these to the person signing at the time.
I was thinking I was asking a bit more simple question than that, but I mean, if the effect of the Court of Appeals decision is to simply abrogate or void the arbitration agreement, where would a decision to that effect leave the provision in the first page of the admission agreement that essentially waives the right to jury trial and punitive damages?
Well, I would say that although that issue is not directly before the court today, I would say that paragraph 4 of the trial court order addresses it. And the finding at issue there is that the court finds that defendants' use of the terms jury trial and bench trial within the same sentence would not give a reasonable person notice of arbitration and would not be understood by someone who does not have training in the interpretation of legal documents. So if the term bench trial does not give a person notice and does not make them understand that if they don't have legal training, then I think that would likely be thrown out too. And in this case, the defendant's nursing home, they drafted these documents. They presented them for signature in the manner in which they wanted to do so. And the long-standing rulings of this court are that any ambiguous terms should be construed against the drafter. So,
Counsel, you raised the dissent in terms of how the dissent was looking at this aspect of these provisions between the contract of admission as well as the arbitration agreement. What's your position on what the dissent has to say about the orientation of the law should favor arbitration agreements in terms of how this court should construe what you say are ambiguities?
Your Honor, I think we also have jurisprudence that says we don't look at public policy in favor of arbitration until we first determine that an arbitration agreement exists. And in the Register case, which was also cited, Register versus Wrightsville Health Holdings, LLC, the Court of Appeals said when you look at public policy arguments, before you actually determine that a arbitration agreement exists, you put the cart before the horse. And I do believe that that's what the dissent does. It jumps over the fact that there was no actual finding that an arbitration agreement existed to look at public policy arguments. And in this case, I do believe that the legislature has already spoken on where they think this should be. And that is in North Carolina General Statute, Section 131E-115. And that is entitled the Nursing Home Patients Bill of Rights. And the Bill of Rights, and the use of that term is very important here because the legislature very much understood the constitutional principles at issue. And they said that each nursing home patient has the following rights, and this is the express purpose: to promote the interests and well-being of the patients in nursing homes. It is the intent of the General Assembly that every patient's civil and religious liberties, including the right to independent personal decisions and knowledge of available choices, shall not be infringed, and that the facility shall encourage and assist the patient in the fullest exercise of these rights. There was also an affirmative duty in sections 117 and 119 on the facility, and that is no facility may require a patient to waive the rights specified in this part. And so I would argue that what we are putting forth, what the defendants are putting forth, is a mandatory waiver of rights. They have not proven the existence of an arbitration agreement in this case, and they're using mere argument to push their points forward.
Are you contending that the waiver would be the right to have a traditional forum such as a jury to have a determination on the rights of the patient? Or are you saying that there is some inherent tension between that ideal that you say the legislature has realized and an arbitration agreement being enforced in any situation?
I do believe that one of the rights that people have is a right to a jury trial. And in this situation, if the defendants wanted to have anyone signing a contract or an arbitration agreement waive these rights, they are required to give proper information on these. What we are asking for is an explanation of documents. Provide the documents so people can read them, explain the terms. What we have in this situation is there is zero evidence that the purported pages 1 and 2 of a purported three-page document were ever shown to a person before she signed them. The trial court found that she was never shown, explained, and it was not made available to her. So if they are asking her to waive a right that she has, there is a duty that they must provide her with the documents and explain them to her. And we also have that in this case, I believe, because there is a fiduciary relation. It is created both de jure, and I would say it is de facto, and based upon the findings in King versus Bryant. In King versus Bryant, the situation involved a patient seeing a doctor, a specialist who is a medical provider. And in this situation, we have someone who had her mother admitted to a nursing home. And as we know, in the nursing home, they manage not just your food, they manage your medicine, they manage your access to your doctor and to your family. This confidential relationship started when the family brought their medical records to the facility, including orders from the physician for admittance, which is an absolute requirement for admittance to a nursing home. a nursing home is set up for people requiring continuous medical supervision. As the defense presented, they do not dispute that the plaintiff went to another facility first, another nursing home that told her, we cannot handle your specialized care. You need to go to the Saber nursing home. So they went to the Autumn Care nursing home. And at that facility, they provided confidential medical records, which included her HIPAA protected health information. And this facility agreed that they could handle her specialized care needs, and she was admitted. And so under King, I believe what we have here is that this patient was referred for the specialized care that this nursing home could provide. The family sought that care. The nursing home requested and received sensitive information provided in medical records and other personal documents, including her Medicare information. No one pointed out that there was an arbitration agreement in existence. And if anything, this, as according to the defense himself, was shuffled in, this one signature page with other documents. And then the patient was admitted.
Is that the
Let me
factual
go.
bridge? Oh, I'm sorry.
I apologize.
Let me go back to how you began your argument, which has to do with the meeting of the mind and the formation of a contract. All of us have had experiences with cell phones, with maybe cable television or other contracts that we enter into in the normal course of life, where we're given, a button that says, if you want to read all the terms and conditions, here are the 500 pages that you can read, or you can just sign. And with the backdrop that an arbitration contract agreement has got to be treated like other contracts, and yet it certainly appears in our law that, for example, the buying and selling of real estate, the promissory notes, deeds of trust, other provisions like that seem to do more than just say, here's a signature page, sign it. Help me understand from your perspective, again, utilizing 21st century, and if we are paperless, what does the formation of a contract look like based on there needing to be a meeting of the minds?
Thank you, Your Honor. So I would say I would look at this in two ways. The first is the formation of a contract in the basic marketplace in a situation where you don't have a fiduciary duty electronically would require that all pages of any contract be presented and available to the person signing it. And we do not have that here. So, and we do not have any evidence from the defense that they did that. And to take it a step further, if a party wants to prove that they provided all pages of a purportedly electronic document, they can put an affidavit in that says that is what they did. And we do not have that here. So whether a party has the ability to view it all electronically or is provided with all of the pages in paper format, either one must occur in order to have a meeting of the minds. Because if a party does not have the physical ability to view all of the terms, then there can be no meeting of the minds. And so whether that physical ability is electronic or in paper format, it does not matter as long as you have the ability to see them. And what we know from trial court order paragraph 5 is that the purported pages 1 and 2 were never available, shown, or explained. So that did not occur here. As a second note, I would also say that when there is a fiduciary relation, you have a different duty. And that is here because when you fail to make a full disclosure of the nature and the import of an arbitration agreement or any contract to a party at the time they're signing or before the time for signature, you have violated that fiduciary duty.
Let me ask you a question about that. Did the trial court address the matter of fiduciary duty?
Your Honor, I believe that the trial court simply said that there was no arbitration agreement in existence and denied the motion to enforce arbitration. So the trial court in paragraph 6 of its order discussed the specialized care needs, and in the hearing, this matter was discussed.
The specialized care needs or the specific issue of whether there was a fiduciary duty?
Your Honor, from my reading of the order, in the trial court order itself, the word fiduciary duty does not appear. This was discussed at the transcript, discussed at the hearing, which is found in the transcript. And I also believe that, I'm sorry.
I said similarly, the majority of the Court of Appeals did not reach the fiduciary duty issue either, right?
That is correct. That was not addressed. The trial court did not, the Court of Appeals did not rule upon that issue, saying they had a separate and independent basis for their review.
So the only place in the Court of Appeals decision that refers to it is in the dissent.
Correct. It is discussed in the dissent, which is how we got to this court. Yes, Your Honor.
In the event that we were persuaded by your argument concerning contract formation, there'd be no need for the court to address the fiduciary duty issue?
Correct. The court does not have to address the issue of the fiduciary duty. However, this is likely to arise again and again, and that is what we see here. And that was the basis of the defendant nursing home's appeal to this court, the fiduciary duty ruling from the dissent. And they specifically requested this ruling here. But there is a separate and independent basis for the ruling upon this matter, and that is the failure to find an arbitration agreement. And that is what the Court of Appeals ruled upon, and that is how we got here.
There was an arbitration agreement in King also, and while I know that the other side says that King is distinguishable from the instant case here, is it your position that the nexus between the facts in the present case and in King would be the specialized care that Saber held itself out to provide, just as occurred in King in terms of the specialized care where there's an arbitration agreement at issue as well?
Yes, Your Honor. And it's not just specific to the arbitration agreement, it's for all the contracts. And so I would say each of the 5 factors at issue in King are at issue here, and even to a greater extent here, in large part because King involved a patient seeing his doctor, and he went home after he saw his doctor. This is a situation where that relationship has a confidential duty in large part because they accepted a patient. They accepted her fully, and that meant they were going to be controlling and maintaining her food, her water, her access to medications, and her access to her doctor. And I would point the court to Abbott versus Gregory, which is 201 North Carolina 577, because that court really did speak to this issue and said that a fiduciary relation exists under a variety of circumstances. It exists in all cases where there has been a special confidence reposed in one who in equity and good conscience is bound to act in good faith and with due regards to the interests of the one reposing confidence. The principle extends to every possible case in which a fiduciary relation exists as a fact. And here you have one side has superiority and influence over the other. And there's a confidence here as they're taking these family members' mother, and they will be controlling all of her access to her needs. The relation and the duties involved don't have to be legal. They could be moral, social, domestic, or merely personal. This court has certainly found a fiduciary duty between an accountant and its client, obviously between lawyers, a trustee and a beneficiary. And the nursing home, in this case, certainly as by the Patient's Bill of Rights, illustrated by the North Carolina legislature, by all of the facts specific to this case, and the specialized care that the trial court found this nursing home was asked and agreed to provide to this patient. All of the facts are here for the same findings as in King versus Bryant. So we would, yes, Your Honor, say that this can be fact specific. And at the time that the patient was admitted to the nursing home, they owed her a greater duty to show her all of the pages of the purported arbitration agreement, to explain them to her, to give them to her in a manner that was not in an iPad that did not allow enlargement, to provide them in a manner that was not in a font that was so minuscule it's virtually impossible to read. They had a duty to provide her with something that she could look at and make a determination. Because when they did not, they have taken away her ability to look elsewhere in the marketplace to determine if she wants to find another nursing home that may be a better place for her mother. They induce detrimental reliance. And this appears to be and could be seen as hiding contract terms until after the electronic signature was applied. And so we have to have some manner to show whether it's an electronic contract or a paper contract that the terms were shown to a party before the signature was affixed. And in an electronic contract, the signature is simply affixed to a document that is printed. So there must be some manner to show this. And I do believe, Your Honors, this goes back to Justice Newby's point as well. When we go back to the best evidence rule, the defendants do have the duty of proving that an actual contract existed. And they have failed to prove that this existed, whether it was by an affidavit explaining how this happened, or providing the original, providing timestamps for how this was shown, or information that purported pages 1 and 2 were shown, and something more than just the signature block was shown to the plaintiff. By not putting forward their own evidence showing how this contract was signed and the manner in which it's signed, we are left with ambiguity as to what she was shown, which was cleared up by the trial court in paragraph 5. She did not see purported pages 1 and 2 of an unpaginated document, and she was only shown the signature paragraph on page 3. This is not sufficient for a meeting of the minds to form a contract. This is certainly not good faith on one side. And this is not something that in equity and good conscience should be repeated over and over. This policy of sign here and we'll fill in the terms later is not a good contract policy for nursing homes or for people in the state of North Carolina. There must be some manner in which a party can prove and steps forward with evidence to prove what was shown to the other party prior to the electronic signature. It was the defendant's burden after the plaintiff put forth an affidavit, and they did not meet their burden of proof. Thank you, Your Honor.
Thank you, counsel. Rebuttal.
Yes.
Thank you, Your Honor. Before I turn it over to my colleague, let me go back to your question, Justice Hudson, earlier about what's a finding of fact and conclusion of law. I would just note that I found the page. If you would turn your attention to the majority opinion in the Court of Appeals, bottom of page 9 and top of page 10, they quote from the sentence in question in the trial court's order, paragraph 4. And even the Court of Appeals says after that, these findings are more appropriately read as a conclusion of law and rather than finding a fact. And with that, for the remainder of the rebuttal, I'd turn it over to my colleague, Daniel Peterson.
Thank you.
Good morning, Your Honors. Daniel Peterson, also for the appellees. And very briefly, I would like to both respond to appellee's argument and bring up respond to the fiduciary duty question. First, according to the appellee today, Ms. Leitner, the authorized representative for Ms. Franklin, simply signed a series of signature blocks without seeing anything. And that belies what we see in the record, which is the paginated, what has been referred to and what was referred to in the trial court's order regarding pages 1 and 2 of the purported arbitration agreement were, not provided versus, the page 3, which contains several terms which would give rise to a reasonable person, particularly an authorized representative for someone's parent, to ask more questions. The facts present in the King case, which this court decided on the whole are absent here, at least as it goes to the material factors. In King, the plaintiff was referred to the defendant's surgeon by his family practitioner for the specific and discrete purpose of having a hernia repair procedure performed. He entered the physician's office, filled out a packet of paperwork, as we all do when we go to see a physician. That packet of paperwork inquired about confidential information of the patient, and unbeknownst to him, contained the arbitration agreement. The physician performed the procedure, something went wrong, suit was brought, and then the physician sought to enforce the arbitration agreement. The court held in King that the fiduciary relationship existed between the surgeon and the patient because, one, it was referred to, the patient was referred to by his surgeon, by the primary care physician, and among other factors, and I know I'm light on time, so I'm just going to cut to the chase. The affidavit does not disclose what, if any, confidential information was disclosed to Autumn Care. Moreover, Ms. Leitner was not the resident herself, but rather the authorized representative acting on behalf of her mother. She exercised discretion in deciding what facility to sign her mother into, first visiting another facility, and I see my time is up, and I appreciate the court's time in hearing me out today. Thank you.
Thank you, counsel. Thank you to everyone. Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina is now in recess. God save the state and this honorable court. Thank you, counsel.
Thank you.